So damage to the property that's caused by an act of God has severe consequences on the landlords and on tenants, anyone living on the property. And often the legal question does arise as to who's responsible for what, who has to fix up the property or cover any damages that are possibly suffered or incurred in this process. Now, unfortunately, it's a really, really sad position to be in. We saw with floods in Durban, and now we're seeing with issues in Cape Town. So the first question from the landlord's part: what is the implication of this sort of damage on the landlord? What are the implications? So obviously now it's twofold. Number one, your tenant has suffered damages. Number two, your property has potentially suffered damages, right?
Absolutely.
But together with this, however, because your property has suffered damages, you may very well now lose a paying tenant. So these are typically the factors that a landlord needs to consider when approaching a situation like this, unfortunately. Now, the tenants, one needs to take a step back though, and before we start looking at the individual implications on the landlord, on the estate agent, on the tenant, we do need to take a step back, and I need to qualify anything that I say with a statement that the terms of the lease agreement would typically govern the relationship between the landlord and the tenant. So this advice is based on what we call common law, which is the law that has been created or that's been developed or evolved over many, many years of case law, stemming all the way back from our history in Roman law, Roman Dutch law. The problem, the one problem is that taking this advice generally could negatively impact you because your lease agreement may actually say something else. And so the first place that a person goes to is to the lease agreement. And in the lease agreement, there are normally terms that need to be considered about what happens in a situation like this, especially with commercial leases. There's often conversations that if a property is rendered unusable, that a tenant may be required to wait for the property to be repaired. It also speaks about who carries certain responsibilities, that rent may continue to be paid, or that there's an entitlement to remit rent, basically not pay rent, but that the tenant is still stuck in the lease, and that when the property is repaired, they have to continue with the lease. Now, I've seen this a lot in commercial agreements, but it does also happen in residential agreements. And we do need to weigh it up, obviously, against things like the Consumer Protection Act and the Rental Housing Act, because it can't be there are certain provisions that wouldn't be allowed. But typically a provision such as entitling the landlord to a certain period to repair the property, that would be allowable, to be honest. So if the lease provides for it, the landlord and tenant need to be aware that they are governed by the terms of the lease. Now, if we take a step back, and because I can't comment on all the possible terms that may exist in leases, just to say that what I just mentioned now is reasonable, and there are obviously unreasonable ones, for example, that require a tenant to pay for the damage caused by flooding when it had nothing to do with the tenant. I can imagine that one would obviously not stand any sort of, would not stand our legal scrutiny. So if we take a step back and we presume that the lease agreement is silent on these points.
Will I be fair if I'm the property owner to say, if I'm the landlord in this, to be specific, to say that I will be putting a clause on my lease agreement to my tenants to say, should anything happen, should floods damage your furniture, it's your own problem to solve. Will that be sound enough to be reasonable, or will that be deemed legally unreasonable?
I feel that
let's just unpack that.
I feel that it's entirely reasonable. There's no issue at all. If it's an act of God and it was something that couldn't have been prevented, there's absolutely no reason whatsoever why a landlord and a tenant can't walk away covering their own damages. The same way that a tenant would not be expected to cover the cost of repairs of the property, a landlord would not be expected to cover the costs of repair of the tenant's furniture. Again, look at the lease agreement, because that's very important, just to make sure that it's 100% covered. And one again needs to take a step back and ask the question, well, an act of God is an act, obviously a natural disaster, as an example, flood, fire, whatever the case is. Now, what you do need to ask yourself is, was there any way that something could reasonably have been foreseen and prevented and mitigated? So as an example, if there's a property that has thatch and there's a specific requirement in our law that if there is thatch, there is a lightning pole that acts as a conductor, right? Now, the landlord neglects to do so, or neglects to ensure that it fits the correct specifications. Now, yes, lightning is an act of God. However, there's certain safety precautions that could have been implemented in order to avoid the damage caused by an act of God. So the fact that the lightning damaged property could, in those instances, be as a result of a landlord's negligence. So that's just one example. We've seen this argument also when it comes to electrical installations, where the expectation is that a tenant occupies a property with electrical installations being of adequate quality. But if they're not, and somehow there's a fire is not in itself an act of God. A fire is caused by electrical issues. There was a short, a property was damaged. In that instance, one can very well say that the landlord did not upkeep the property, did not maintain, and it caused an event that obviously damaged the property. So one does need to distinguish between simply looking at things like fire, wind, storms, lightning. If, for example, a roof leak was reported by a tenant and it was noticed there was a roof leak, the tenant emphasized how serious this roof leak was. Maybe a tree fell on the tiles and it was just a matter of time before there were going to be heavy rains, and the landlord continues to neglect to repair the roof, and suddenly there's water damage. One could potentially argue that this is the landlord's responsibility. Remember, our law works in a way where we still carry the responsibility to mitigate damages. And if we foresee the potential of damages, we need to mitigate. So even in that last example that I gave you, with the potential of damage being caused through broken roof tiles due to a tree, if the damage is caused immediately and the tenant didn't have any opportunity to move his furniture, then you could hold the landlord responsible. However, if the tenant, knowing that there's a leak and keeps the furniture, then later goes to the landlord and says, well, you know what, my furniture did sit there for a week and you can see that it got damaged, I want you to replace it. In those instances, the tenant didn't actually take care of their furniture. So there is a level of intuition and reasonableness when it comes to this conversation. But as I mentioned before, when I'm referring now to an act of God, it's a situation that couldn't have been avoided. The flooding couldn't have been avoided. No one knew. So it wasn't as though the property was below a certain flood line. And the landlord, because this actually happened on an occasion where a property was built below a flood line. Everyone knew it was below the flood line. And if I'm not mistaken, there was a death. And this actually went to court. I believe that the landowner was prosecuted. And I'd actually need to check what the result of that was. But the reality is that by conducting yourself, knowing that there's a possibility of something going wrong, it's a very different conversation to having a house, everything looks perfect, you've got absolutely no idea that the flooding is going to happen, and then all of a sudden it hits you. These are the circumstances where I am saying that normally, under our common law, the landlord would be responsible for the damage to his own property and the tenant would be responsible for the damage to their property. The contract should govern the relationship between the two, but if it is silent, then the next conversation is, well, what happens to the lease? So to wrap off the insurance conversation, insurance, very good idea. And make sure to check your policies. The whole point of insurance is to insure against unforeseen circumstances. So unfortunately, you're going to have to potentially try foresee unforeseen circumstance and make sure that your policy covers it. But it's rare to see a situation where a landlord would cover household contents of a tenant, but it does happen. So it's also something to bear in mind that as a landlord, to cover yourself, you sometimes find insurance policies, and most household insurance policies would have a clause providing for potential damage to a tenant's property. This particularly happens in situations, for example, where say there's a crime, and now there's an argument between the tenant and the landlord that the crime could have been prevented had the landlord repaired the electric fence that the tenant had reported was damaged some months back, right? And now it becomes a dispute that the tenant suffered a loss, and it's actually the landlord's fault that the tenant suffered a loss because the landlord should have acted sooner. Interestingly enough, there are insurance policies, and it would cover certain natural events and natural disasters under that specific policy. So just double check that you as a landlord, if you do have that policy, you can potentially claim against it. And remember, a lot of these policies also cover things like loss of rental and the repair of your property and any third-party liability. So potentially, if you're at fault for any reason, you might actually be able to get covered, including certain household contents belonging to the tenants. Tenants, on the other hand, it's basically direct insurance. You have 5 assets, make sure that they're all covered, and that anything that happens to those assets, you get to claim them. Laptops, whatever it is, right? Appliances. So yes, insurance, very good idea. Now, but if you take a step back from insurance, because a lot of these questions now, I suppose, are based on, but who should the finger be pointed at? And unfortunately, if people don't have insurance, because presuming that, if they've got insurance, they wouldn't be needing to point the finger. The insurance companies would do this in the background and would have this fight with each other in the background. The conversation is, well, what happens? What happens to the deposit? What happens to the tenant? Can the tenant cancel the lease? So the next part of the conversation, so we dealt with who's supposed to carry the damages. The next conversation is what happens to the lease? And again, look at the lease first, and the lease would govern that. If the lease is silent on what happens next, more often than not, we need to look at the materiality of the destruction caused. I rent a property, or I rent any sort of agreement that's based on hire. You hire something for a very specific function, and certain things are material in that function, right? Now, if, let's say, the loss, for example, the damage is a small little corner of the house where no one goes, and it's barely an inconvenience. And yes, it's completely destroyed, but it's no less than 1 square meter of no materiality whatsoever. Barely anyone actually went to that side of the house, and there's no other potential risk caused by it. Then the property is still usable, and there can still be use and enjoyment. And the conversation there is about use and enjoyment. That specific item that was given or hired out, can it still be used and enjoyed to the same or similar degree as it was previously? And depending on the materiality of the reduction in use and enjoyment, would then necessitate or would then lead to a tenant potentially saying, sorry, unfortunately, I hired this property for A, B, and C. Those were very material desires that we had, and we wouldn't have rented it out otherwise. And now, since this has been destroyed, I no longer want the property. And that is certainly something that can play a part when it comes to something like this. You may also find middle grounds where it's not as material, but it does reduce the use of the property somewhat. And in those instances, there can be an argument to be made that now there's a partial use that's being provided, and that partial use requires partial rent to be paid. But usually you would find that either the property is destroyed and the tenant no longer wants to stay there, or the property is barely touched and the tenant can't really argue that their use and enjoyment has been in any way impacted. So the position or role of real estate agents, I've always said, is obviously a professional role. So real estate agents have to be in the position to advise their landlords and their tenants accordingly and appropriately. To the degree that if you go through some of the PDE requirements and PDE study notes, there are certain legal components to this. So it's not to say that an estate agent or a leasing agent has to be a lawyer, certainly not. But there are certain basic legal knowledge that's required. I suppose that's why I work so closely with estate agents, in order to try and just ensure that as the law develops and evolves, that the estate agents are kept up to date. And that's obviously also the reason why, continuing professional development is so necessary in all spaces of professional work. So to answer your question, what is the role of an estate agent in a situation like this? So the first part of it is when entering into the lease agreement, it's normally the estate agent that provides a lease agreement to be signed. So I would say that the first role is that the estate agent be prudent to ensure that the lease agreement covers all the necessary aspects of foreseeable and unforeseeable. And obviously, you know what? There are certain not every contract can deal with every single scenario. It would be virtually impossible to fit that in enough pages for anyone to be willing to read or sign. But there are certain things that you can very much in short address and deal with. Is it necessary that the lease agreements say that the landlord cannot be held responsible? There is generally a clause like that in most lease agreements, to be honest. So if you are using a correct lease agreement, then it should have a clause. It's a disclaimer of liability. If you don't have one, you should certainly consider having your lease agreement considered. So that would be the first role of the estate agent, making sure that the contract adequately provides for situations where you can avoid disputes from happening. That's the point of a contract. Things are always going to happen. How things unfold is where the contract comes in, and where the law is strict to say, well, the contract says that if A, B, and C happens, there's a certain consequence, and this consequence needs to be followed. Whether it's a dispute resolution provision, whether there's a transitional period, whether there's a period of time that the landlord is entitled to have in order to repair the property and place it in the same condition as it was before. Yes, it is a good idea that lease agreements speak of this and speak of this generally. It doesn't need to refer specifically to damage caused by a flood or a fire, because one can in general speak to the destruction of the property for any reason whatsoever. And this, I feel, is something that estate agents need to be aware of and need to ensure that the lease agreement provides for. The second role is obviously the facilitating of the conversation once something does happen. Now, again, as an estate agent, it might seem an easy shortcut to just give any version of the lease and get people to sign it and not worry about it again, hoping that nothing goes wrong. But this is exactly where things do go wrong, because when something happens, anything, a tenant breaches, fails to pay, claims there's damage to the property, wants to remit rent, all that can be avoided, provided that there's a good lease agreement in place. So does an agent have to worry about having an easy conversation after the fact? Not as much when the lease agreement is good. But in any event, the other role of the estate agent is to make sure that there's some kind of facilitation in the conversation. So as this happens, the estate agent needs to get involved, needs to assess, needs to speak to the landlord, needs to speak to the tenant, and needs to make a determination. Take legal advice. Try figure out what it is that both parties want. Is there a amicable solution? Is there going to be a dispute? Is there any way to manage this dispute better? That's all part of the estate agent's role in the middle of the contract, in a situation where something has happened to the property and now the parties are trying to figure out who needs to pay for what and what happens to the lease agreement.